Hey everyone, welcome back. In today's video, we've got a packed lineup. Two fools who managed to push the wrong judge too far, a couple of judges stepping aside for solid reasons, and an update on our favorite sovereign, Eric Martin. We'll kick things off in Courtroom Municipal Court, where a guy out on bond for driving without a license still thought it was a smart idea to keep getting behind the wheel. Let's dive in.
Look, Mr. Gregory, and I'm not expecting for you to respond. I'm going to set this case for a pretrial conference on the same date as the other pending cases. You are facing a lot of jail time in these cases, and I don't want to hear any excuses from you today or at any time about why you're driving. I'm fed up with you! Constantly being in this courtroom driving against court orders while pending cases are happening. This is constant, well before Mr. Loftus was ever involved in representing you. If there's one more incident between now and the next pretrial where you come in to this court having gotten another citation, you might as well just walk to the jail. I'm fed up with you. I can't believe I'm letting you go. I can't believe I'm letting you walk out this door. It's constant with you. And I don't get why I keep being so generous to someone who just thumbs his nose at me. Get your client out of here. I don't want to see his face until the next pretrial. Bond is set, $5,000 personal recognizance, not to operate or be in the driver's seat of another vehicle. Thank you, Mr. Loftus.
Now you see why I enjoy watching this judge. He's fair, strict, and runs his courtroom with authority. We're sticking with him for the next case, which happens to unfold in front of a group of kids on a courthouse field trip. They're about to get a real-life lesson in what it means to mess around and find out.
Okay, Ms. Sullivan, did you understand all of the rights and plea options I just explained to everyone?
Yes.
Do you have any questions regarding any of those?
No.
Do you recall receiving a copy of the
Yes.
citation that was issued on November 1st, 2022?
Yeah.
Okay. You're charged with 2 counts. The first charge is driving under suspension. That is a first-degree misdemeanor. If convicted of this offense, you face a maximum 180 days in jail, a maximum fine of $1,000, and I could impose a license suspension of up to 1 year. And this is a 2-point violation. So do you understand the consequences you face if convicted of that charge?
Yes.
The second charge is use of headlight beams. That is a minor misdemeanor. That is punishable by a maximum $150 fine and court costs. Do you understand that?
Yes.
The officer, I don't know why he checked not applicable on the ticket, but it is very applicable. If you need to provide the court proof of insurance that on the vehicle you were driving on November 1st, 2022. If you're not able to provide this court proof of insurance on the vehicle you were driving that day and are convicted of this offense, you do face a mandatory non-compliance suspension with the Bureau of Motor Vehicles. Do you understand that potential consequence?
What did you mean by non-political, whatever the fuck did you say?
Excuse me, what did you just say?
What do you mean by non-political, whatever the fuck did you say?
Take her into custody. Did you just use the F word in front of these kids and in front of me? Did you just do that? Take her into custody, go down in jail, and then think about what you just said to me in this courtroom in front of these kids, and then maybe, just maybe, I might take your case up later today. Okay? Go. Get out of here.
Sir, come.
Get out of here.
This is actually an unusual situation. Normally, when a lawyer is removed from a case, it's the defendant who makes that call. something we see often with sovereign citizens who fire their attorneys for not indulging their bizarre beliefs. But hey, the issue comes down to a disagreement in legal strategy. Since the defendant has the right to choose his approach, the attorney is requesting to step aside, likely because he doesn't want to put his license on the line for frivolous motions. And honestly, it's hard to blame him when the defendant insists on backing himself up with his own imaginary legal team.
Case number 25W700388, the state of Michigan versus Bradley Peterson. Okay, counsel, your Mr. Perpenwalk Keller, your name for the record, please.
Good morning, Your Honor. Yvonne Parabon Keller, P84328, appearing on behalf of Mr. Bradley Peterson, who is present today in the courtroom.
All right, thank you. And Mr. Peterson, for the record, please.
Bradley Thomas Peterson.
All right, thank you. And Ms. Bella, your appearance for the record, please.
Good morning, Your Honor. Michaela Vella on behalf of the people, P87185.
All right. And so today is the date scheduled for a probable cause conference in this matter. And counsel?
Your Honor, I had the opportunity to speak with Mr. Peterson in the breakout room, and this is something that the court may be aware of, and I am not. Mr. Peterson had recently come out of being incarcerated for the purposes of these proceedings. He got out on bond, and that was arranged. Mr. Peterson and I had discussed a number of things in the breakout room. We discussed going forward with strategy in this case, and Mr. Peterson had informed me that he had filed a motion with the court to remove the judge from this case. And regardless of whether that motion had been filed or not, or whether he intended for such a motion to be filed, I advised him that I was not comfortable with doing so and that I did not agree to do so for the purposes of this case. And as such, him and I discussed that this was going to be a stopping point in going forward with representation. And as such, we parted amicably. And at this time, I would ask to be allowed to recuse myself from this case, Judge.
I really don't think it's in your best interest to represent yourself, especially when you don't even understand the basic procedures, like how to properly request court transcripts.
So you are asking to be removed from this case because Mr. Peterson filed a motion on his own and not with discussion with you, and you're not comfortable with that motion.
That is not the sole reason, Judge. Mr. Peterson insisted that the only way that he would be comfortable with me representing him in this case is if I continued and persisted with this motion. I do not agree with the motion that he is filing, and he said that he would prefer to go on his own if I would not go forward with this motion in his behalf. And we had a civil discussion about this, Judge. We did not have a fight or anything. I want to make that clear. Mr. Peterson and I have a good relationship, speaking-wise, so I'm not trying to cast aspersions on him at any point. I want the record to reflect that. But this is an impasse that we have reached, and that is the reason I have brought this to the court's attention.
Okay. All right. The court will note that there was a motion that was filed today asking for this court
For the videotape, hearing a bell and charges.
Okay, we don't have videotape. You can request a transcript, certainly. That's, yes, you can certainly request a transcript.
Yeah.
You don't need a motion for that. You can request a transcript without a motion, just so you know.
Okay, well, we did it over Zoom, so I just assumed that you'd have a videotape of it and not a transcript of the 7th, of January 7th, when we had a bail bond discussion and the charges of trespassing and assault in the city of Woodhaven. We did it over Zoom.
I understand we did it over Zoom, but we don't, that was not recorded over Zoom. It was
just on transcript.
Recorded on our transcript.
Okay, well, I'm gonna have to file a motion for that, I guess, because I don't.
No, sir, what I'm saying is that you don't need a motion for transcripts.
Okay.
You can just request a transcript.
Okay, yeah.
There's a fee that you have to pay, but it's not a motion.
And that, my friends, is a flat-out lie. I actually dig into case histories for the people I cover, and I love it when they hand me the proof that exposes their own dishonesty. He cited Judge Grant in his case against the city of Woodhaven, which led me to a federal case in Michigan, Brad Peterson v. a long list of defendants. He literally sued the state, the city, the mayor, the judge, and the prosecutor for civil rights violations. While there was mention of an injunction, the appeal shows Peterson never objected to the denial of his motion, which let the court adopt it outright. And even if he had, they still would have ruled against him. Magistrate Grant did dismiss some of Peterson's claims, but the city's injunction stood firm, contrary to what he said. To cap it off, in December 2024, the appellate court dismissed everything against the state and its co-defendants with prejudice. So, stop lying. You're way too old for that.
Request that. Also, I request on the Michigan Courtroom 2.003. I believe it's filed that on the 17th on Friday or something like that. So
Okay, hold on, just a moment. Okay, well, counsel, I will allow you to, I will grant your motion to terminate representation specifically as far as moving forward, but counsel, I would just, if you can just stay on these proceedings.
Oh, of course. I would sure, yeah, I have no problem.
Let me finish, please.
I'm sorry.
To advise Mr. Peterson appropriately if he's getting into some territory he shouldn't be getting into, okay?
Of course, Judge.
Thank you. So the motion you filed today, sir, is regarding the Zoom video that does not exist, but the transcripts you can certainly request, correct?
yes.
That's all of this one. And we filed something on January 17th, and you're requesting our 2.003 to dismiss, qualify the judge as follows. Filed the motion in good faith. Fair bond conditions and restrictions to stop U.S. public protests at City of Winnebago Public Schools are biased favors given to plaintiff. Okay, well, sir, I can tell you that that's not, that's a condition this court put in because that's what's alleged as a violation. So to protect the complaining witnesses, that's what the court put in. Just as in any assault case, sir, I put a no contact provision in. And so that is why I did that, not because there's any bias at all.
Well, if you keep
not at all.
If you keep reading, Your Honor, you'll see that the U.S. Federal Court, Judge Grant, Your Honor, because the city of Woodhaven tried to put a PPO on them, specifically told them, case dismissed, that he cannot violate my constitutional rights.
Sir,
and I believe that's the issue.
Oh, hold on, please, just one moment. I understand that you think that that's the issue. I'm not trying to violate your constitutional rights. What I'm trying to do is that there is, right now, that there's a complaining witness. There are allegations, and so the court, as condition of bond, has put certain parameters and conditions of bond on. Just as, like I just stated, just as if there is an assaultive, somebody with assault and battery or domestic violence, they're not allowed to return to the home or wherever the victim lives. They're not allowed to return to the victim's place of employment. They're not allowed to contact the victim. Those are all conditions I put in. Somebody with disorderly conduct, I put certain provisions in there, whether they can use alcohol or not use alcohol, whether they have to use testing or not testing. It's not intended to violate any rights under the U.S. Constitution. The purpose is for protection of the complaining witnesses and protection of society if this court deems necessary.
That's if somebody violated a law. I haven't violated nothing.
Sir?
I'm with you.
The allegation is that you assault or resisted, obstructed a police officer causing injury and trespassed.
That's just an allegation.
You're correct. But as a condition of bond, there are certain factors the court has to take into consideration when assessing bond, and the court has judicial discretion to assess bond conditions. That is what this court did. I didn't place you on house arrest, told you couldn't move anywhere. I didn't do any of that, sir. I simply put forth conditions relevant to the allegations therein. And sir, I'm very much aware that they're allegations only.
No, you need to read the whole thing, other than just one. I got like 15 issues in there.
15 issues.
Yeah, you need to read the whole thing. Also, Your Honor, I publicly protested today in front of your court.
Okay.
but none of your police came out to arrest me because that's my constitutional right to do. I'm not ignorant of my constitutional rights. I'm not ignorant. A judge told me a long time ago, ignorance of the law is no excuse.
Right.
And so I studied a little bit. I don't know a lot, but I know my constitutional rights. I've done read your European Constitution over and over again. Actually,